Welcome to the annual Ronald Reagan banquet at our 42nd CPAC. What could be more appropriate than now to give the Ronald Reagan Award?
Millie Hallow, you inspire us all to keep up the fight for our future.
I'm done. Thank you so much.
Under Tom Fenton's leadership, Judicial Watch has been unequaled in defending our ideas and the ideals of our founders.
We're proud to present Sheriff David Clark with the Charlton Heston Courage Under Fire Award.
Present tonight the Jean Jordan Kirkpatrick Prize for Academic Freedom to the University of Virginia's Professor James Caesar.
Winner of the 2015 CPAC Journalist of the Year Award, Jim Gary.
Ladies and gentlemen, our next session is entitled Dusting Off the 10th Amendment, the Future of Federalism, moderated by Bridgett Wagner.
Come on up. Hello, good afternoon. For those of you who haven't read the 10th Amendment in a while, I thought it might be helpful to give you a simple translation. The federal government can only do what the Constitution explicitly says it's allowed to do, and the states and the people can do anything that the Constitution does not forbid. Washington tends to fail at the first and forget the second part. It gets worse. As we've seen through executive actions and mandates, Washington has undermined the balance of power and the rule of law. Today we've got three outstanding champions of federalism who've joined us. I'll introduce them individually and they'll come up and make their brief remarks, and then we'll join together in discussion afterwards. They are all great advocates for what we call bringing government closer to home. Our first speaker is Chairman Bob Goodlatte, who represents the 6th District of Virginia in the Congress. As I said, he's chairman of the very important House Judiciary Committee. And for those of you who don't follow Congress closely, this committee handles issues ranging from immigration reform to terrorism and crime, legal and regulatory reform, oversight of the Departments of Justice and Homeland Security, and protection of our constitutional freedoms and civil liberties. As you can imagine, he's a very busy man right now. Chairman Goodlatte, if you could come on up. He's also a member, I want to point out, of the Congressional Constitution Caucus and the 10th Amendment Task Force. Join me in welcoming Chairman Goodlatte.
Bridgett, thank you for that very kind introduction, and it's a pleasure to be here with all of you, and especially with Governor Brownback, a former colleague of mine in the House of a number of years ago, and Attorney General Pruitt. We're delighted to have you here, and thank you so much for the work that you and 25 other state attorney generals are doing in standing up for your rights and for the United States Constitution in the lawsuit that you've brought in Texas. I want to talk to you about the elegance of the 10th Amendment. We forget about it, but it is an elegant amendment. And that elegance lies in its summation of the very purpose of the Constitution. The 10th Amendment states that the powers not delegated to the United States, that is, to the federal government, by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. It essentially says the enumerated powers of the Congress, the President, and the federal courts belong to them, respectively, and all other authorities belong to the states and to the people. Insofar as the 10th Amendment simply summarizes the purpose of the Constitution itself, in a significant sense, it's not that the 10th Amendment has been forgotten. Rather, it is that the original purpose of the Constitution as a system of limited or enumerated powers has been lost sight of. I agree with you. The Supreme Court has encouraged this result over the years, not by misinterpreting the 10th Amendment itself, but by misinterpreting the Constitution's enumerated powers in a way that substantially broadens federal authority. Take the Commerce Clause, for example. James Madison and Alexander Hamilton, writing in their defense of the Commerce Clause in their Federalist Papers, made clear that its intent was to allow Congress, should it so choose, to break down barriers to trade nationwide, to facilitate growth of a national economy. Many people forget that the prime purpose of calling the Constitutional Convention in 1787 in the first place was to create a Commerce Clause, because at the time the state legislatures were closing their state borders to trade by imposing rules that favored their own state's goods and services at the expense of others. James Madison wrote in Federalist No. 41, the Constitution would grant the federal government several powers, including the Commerce Clause authorities necessary toward maintenance of harmony and proper intercourse among the states. And as Alexander Hamilton wrote in Federalist No. 11, the Commerce Clause would allow Congress to break down legal barriers to trade between the states. As Hamilton wrote, an unrestrained intercourse between the states themselves will advance the trade of each by an interchange of their respective productions, not only for the supply of reciprocal wants at home, but for the exportation to foreign markets. Commercial enterprise will have as much greater scope from the diversity in the productions of different states. As James Madison summed up the purpose of the Commerce Clause in his speech in the Virginia Ratifying Convention, there are regulations in different states which are unfavorable to the inhabitants of other states. This will not be the case when uniform regulations will be made by Congress under the Commerce Clause. But what did the Supreme Court do with a Commerce Clause intended to allow Congress to reduce barriers to economic growth? It read the Commerce Clause expansively to allow Congress to instead impose its own additional barriers to economic growth. When an enumerated power of Congress is read by the Supreme Court so broadly, the 10th Amendment's reservation of other powers to the states and to the people becomes less significant. Indeed, the Supreme Court now rarely looks to the 10th Amendment, and when it does, it has tended to do so only to prevent Congress from directly ordering state governments to carry out federal programs with their own state staff and state resources, as it did, for example, in Prince versus the United States, where the Supreme Court held Congress could not directly order state officials to carry out a system of federal firearms regulations. So, the 10th Amendment has effectively been pushed aside as the Commerce Clause has been turned on its head. Thankfully, we have great governors today, great state legislators, and great attorneys general who are pushing back, and we need to encourage them to continue to do that, because it is so important that government be closer and closer to the people, and government in Washington, D.C. has the tendency of being just the opposite. I've got much more that I'd like to share with you, but I want to stop now so that you can hear from the governor and the attorney general and have some time for your questions as well. Thank you very much. Keep up the fight for conservative values and limited federal government.
Thank you, Chairman. Our second speaker, Kansas Governor Sam Brownback, is in a bit of a unique position. He served in the United States House of Representatives, where he headed a group of members who called themselves the New Federalists. And then after serving 2 terms in the United States Senate, he honored his own term limit pledge and returned to Kansas to run for governor. When he took office in the governor's office in 2011, the state was in its 3rd year of declining revenues. 110,000 Kansans were unemployed, and they were facing a projected deficit of $500 million. He worked with the legislature and turned the deficit around to a nearly $500 million ending balance in 1 year. And employment has increased every year he's been in office. He follows what he calls a red state model of governing, and I know he's a proponent of what many of us call competitive federalism among the states. Governor Brownback.
Thank you. Thanks, I appreciate that. Well, good afternoon, everybody. Hope you're enjoying CPAC. Great event. Great place. I've been talking to a lot of people that are pretty tired after being here the full period of time, and they're going, I'm running on fumes, but I'm liking it all. And what you guys are doing is fabulous. It's a fabulous group that's getting together. One of the great frustrations for me is how much time I have to spend as a governor pushing back against the federal government. And we're having to do it all the time. And you have to do it on a number of issues. Probably the biggest one, the ACA, has been the recent one. You're going to hear from the Attorney General of Oklahoma talking about Obamacare and the amount of effort that we have to spend pushing back against the federal government. The system was never designed to work that way. The system, as the chairman just pointed out, was a system of limited federal government and your general authority in state and local and to the people. And yet you got the system basically kind of flipped on its head right now, with the federal government taking more and more power and pushing things on the state and local units of government and the requirements that we then have to push back. The good news is, I think you're going to see the pushback be more and more effective from the state, local, and individual level than it has been in the past. I think we're in an era now where federal government is way overspent, way overbuilt, and to the point that it's going to have to start coming back. And you've got more and more people pushing to say, look, the system's not designed to have your general government functions run at the federal level. It doesn't work well that way. When you try to get the micromanagement coming out of Washington, it doesn't work well for a broad nation that goes over as many time zones as we do, with 315 million people, or whatever the current number is. It doesn't work well. You need individualized states being able to deal with their particular situation that happens there. It's government closer to the people, and it's where innovation happens at this local level. And I want to give you a quick example of innovation and the competition that happens between states that makes for a better system. Right now, the states are in a tax competition. We're competing to get our taxes down so that we attract more people, more businesses, and more jobs to the states. This is an important thing to do. And that creates a situation where you've got this competition back and forth, and the innovation then that comes out of that can be used at the federal level. Right now, we went in the state of Kansas and taken our income tax rates down from 6.45 to 4.8 and went to 0 on small business taxes, 0 on LLC, sub-S. Better than New York, better than California, better than Texas on small business. All right, check me out on that. And that is a good thing to have that competition. So now we've got small business growth, record numbers of new LLCs filing in the state of Kansas. We've got growth in small business income and small business employment. And nationwide, we've got a reduction in the number of small businesses in the United States. This is a terrible nationwide trend because you grow off of small business. In Kansas, 3/4 of the people work for themselves or for somebody with 10 or fewer employees. We need to grow small business across America. So we went to 0. What if the federal government looks at this model later on and says, wow, look at that growth of small business that's happening in Kansas. Wow, look at the amount of employment that's growing there. Wow, look at the wage income growth. In Kansas City, a city that's divided close to equal between 2 states. When I first started in office, work in Kansas, the wage rate is about 40 cents an hour higher than in Missouri. We go to 0 taxes on small business. It's now $2.93 an hour higher working in Kansas, wages, than on the Missouri side. $3 an hour. That's the sort of thing that Republicans and conservatives want to see happening. We want to see people grow. We want to see people making more money. And we do it through competition. And we do it through putting that on forward. There are other areas that we need to be able to have flexibility in. One, I think, is in welfare reform. We need to be able to have the flexibility to work with people in our state, and our objective is to get people out of poverty. That's what we want to do with the public assistance system. What was started in the war on poverty under LBJ, lots of money put into a system, and yet the poverty rates nationwide have virtually stayed the same. Have you noticed this? We've spent trillions, up to some people say $20 trillion in the war on poverty, and we've got the same level of poverty in the country after all those years. You need states innovative and working in this space to see what can we do to get the poverty rate down. That's what it's about. And it involves three things primarily. It involves work, education, and family formation and family structure. You get those three right, you can move people out of poverty. So what we want to do in the state of Kansas is have more flexibility to require people that get public assistance to apply for work or to take job training as a way of getting them out of poverty. Unfortunately, in many of these cases, you have to ask for federal waivers to be able to do this, instead of saying, okay, let's let the states innovate, with the objective being not how many people do you have in poverty, but how many people do you get out of poverty. That's what the objective should be. And this to me is a great area for us to innovate and to be a key part of as a conservative movement, is what we can do to get people out of poverty. And we've got better ideas to be able to do it, but you have to be able to innovate. You have to be able to put those models in place at the local level. Got more to say, but not time, and I look forward to the questions and answers. God bless you all.
Thank you, Governor. Before our next speaker took office as Oklahoma's 17th Attorney General, Scott Pruitt served for 8 years in their state Senate. He was a champion of reform and accountability and expanding freedom. As Attorney General, he's established Oklahoma's first federalism unit in his office. He's known as a national leader in the cause of restoring the proper balance between the states and the federal government. And he's launched or is party to major challenges, major legal challenges on Obamacare subsidies, the administration's executive action on immigration, EPA's activist agenda, and the HHS mandate on Obamacare. Columnist George Will has called him one of the Obama administration's most tenacious tormentors. Congratulations. Translation, he's a tireless defender of the Constitution and our precious liberties. We look forward to hearing from you, General.
Thank you, Bridgett. Thank you very much. And I didn't know they were handing out awards for the tenacious tormentor of this administration, but I'm glad to be a part of that. There's a lot of that working around. But I just want to say it is wonderful to be back at CPAC. Good afternoon to you. It is wonderful to be here. It's great to be on this panel with both Chairman Goodlatte as well as the governor from Kansas, Governor Brownback, both of whom are champions for conservative causes, making a difference both at the federal and state level, and it's just a pleasure to be on the panel with them. You know, June 2nd, 1979 is not a date that you see in many history books, but it's significant nonetheless. It was June 2nd, 1979, when Pope John Paul II went into his country, his former Poland, as he went in as Pope, to spend time with his fellow countrymen and visit with them as the communist-occupied Poland. And as he spent time with them, he was speaking to the heart of the people, and he said two things to them that I think are very important for us today. He said to the people, "You are not who they say you are. Let me remind you who you are." And as we gather here at CPAC in 2015, I wonder if in the future, as patriots, as Americans in the future look back on this time, will they look upon this conference, will they look upon this time and look at the leadership of Chairman Goodlatte, the leadership of Governor Brownback, the leadership of others, both at the federal and state level, and say those were individuals that were committed to the cause of liberty during a very difficult time? Because I will say to you that we are living in a time in this country where I never thought we would be. I never thought we would be living in a time where fundamental concepts, constitutional structures, checks and balances, vertical checks and balances in federalism and rule of law are under such attack. It is this president who has said unapologetically numerous times, "I have a pen and I have a phone," sending a message that he's going to regulate and legislate through the executive branch at the expense of horizontal checks and balances and at the expense of vertical checks and balances. We live in a very unique time. And I will say to you, as the Attorney General of Oklahoma, as Bridgett shared, I set up the first federalism unit in this country in my office to focus on those breaches of that constitutional framework that impact your liberties and my liberties. And we are on the front lines. We have a case upcoming this week King versus Burwell, that Oklahoma began the challenge in September of 2012, that said to the administration, the IRS's rule to say that they're going to disregard the decision that the governor of Kansas made to not set up an exchange. And because the governor of Kansas did not set up an exchange, what does that mean? That the employer mandate penalty cannot be assessed in Kansas, and the individual mandate is impacted to the degree that it likely cannot be enforced. And we have taken that challenge to the courts to say that the president's action to disregard the decision of the states is unlawful, unconstitutional, and he should be held accountable. And that case is being argued Wednesday of this week, and I'm hopeful that we will see victory, and the very structure of the Affordable Care Act will fall because of the challenge of the states. It is the collection of 26 states that joined together to say to this president, his action, his executive action on immigration is unlawful. This president has said to Congress, Congress, if you would just act, I wouldn't have to. You've not acted the way that I want you to act, and he has tried to pinch hit for Congress. What's fifth grade civics? That it takes two branches of government to pass a law. It takes Congress acting, and it takes the president signing the law, and just because Congress has acted or not acted pursuant to the wishes of the president doesn't give the president the authority to pinch it and fill in the space. It is the legislative prerogative. It is the legislative prerogative to act or to not act. And Mr. President, you have violated the law, you have violated the Constitution, and 26 states have held you accountable in the state of Texas, and now that injunction is in place preventing you from your unlawful action in those 26 states. That is a good thing. So when we talk about these issues of federalism, and we know about horizontal checks and balances between the branches, executive and legislative and judicial, but we oftentimes forget about the vertical checks and balances, and it's been referenced here today. Vertical checks and balances is federalism. It says of the federal government, you are a government of limited powers, of enumerated powers, and you only possess that. Everything else is reserved to whom? The people and the respective states. It's not some quaint notion from the 1700s. Federalism in action means that your liberty is protected when it is enforced. And I will say to you, as an attorney general at the state level, there could be no more consequential time to be serving, because we don't have to go to the legislatures to get a vote. We can look at the Constitution and look at the action of the federal government and take action in the courts to hold them accountable. And I recognize it takes time to do that. But it is important not only for this time. These issues of health care, these issues of immigration, these issues around Dodd-Frank and other pieces of legislation at the federal level, they're very important in and of themselves. But I think what's more transcendent, what's more important to your future and my future, is the fact that we respect rule of law, we respect the constitutional framework, we make sure that the executive branch does not exceed its authority and engage in executive fiat. There's a phrase that I use in my office often, lex rex. The law is above the king. And even this president and the federal government, they are constrained by something much larger than themselves. It's called the Constitution. And we must be about enforcing it for the betterment of our children and grandchildren in the future. Teddy Roosevelt one time said, in any given situation, when you're making a decision, the best thing you can do is the right thing. The next best thing you can do is the wrong thing. The worst thing you can do is nothing. I will say to you as Attorney General, we're not choosing the latter course. We are charging the hill to make sure that your liberties are protected, and I think we're making a difference. God bless you, and I look forward to your questions.
Thank you, all three, for really teeing up a great discussion. I think you all touched on some really important topics. I wonder if we can start with, since Attorney General Pruitt, you mentioned the King versus Burwell decision, which is coming up this Wednesday. I wonder if we could just have you fill out, how will that play out? What's the timing? The hearing will be Wednesday. When should we expect a decision? And what do you think is likely to happen? And then I'd love to just come down the line, Congressman Goodlatte, after that. I wonder if you could tell us, what is Congress going to do? Should they rule in favor of King and these subsidies be struck down? And then Governor Brownback, what should the states do?
Well, Bridgett, I think that it was very encouraging that the court took the case up as early as it did. There was not a split of the circuits on the issue, and moreover, this case is different than the challenge NFIB versus Abilia. It's the case that came out in June of 2012. That was a challenge that went to the authority of Congress to actually pass the law. Did they have the authority under the Commerce Clause to pass the Affordable Care Act? The court said no, by the way, with the Commerce Clause, but then filled in the blank with taxing power. But here, this is about statutory construction only. It's about what did Congress say in the law and the decision that should be respected by the states and as they set up exchanges or did not. And so I'm very encouraged that the case has been taken up this quickly. We'll have a decision by June. We know that. The case will be argued on March 4th. I'm encouraged where we are. It takes 4 justices to get the case up. So I think there's momentum with our arguments presently, and look forward to hopefully a favorable decision in June.
Great. Chairman.
Well, I hope the states are very successful and that you are able to win this case, because just like with the individual mandate, this is a key component of Obamacare and could be really what's needed to take down a very bad law and give us the opening to do the right thing. We shouldn't just sit back and wait for that to happen, because we do have a need for health care reform in our country. We need to have health care reform that gives patients more choices, not this system that gives everyone a homogenized, one-size-fits-all approach. We need to make sure that it's more centered between the patient and the health care provider and not a government bureaucracy dictating everything that happens. So we should be ready with health care reforms that takes that respect for the 10th Amendment that we're here talking about today and the recognition of the original purpose of the Commerce Clause, which was to open up competition and do things like give people the opportunity to purchase what they want to purchase across the country, to have medical liability reform, but medical liability reform that respects the states and the state courts so that we tie it to the expenditure of federal dollars and make sure that we're not dictating in state courts what the outcomes have got to be with regard to medical liability reform. We can do that if we're planning ahead, and we're doing that right now in the House, getting ready to have our own real patient-centered healthcare reforms that are based upon choice and competition, not based upon bureaucrats deciding everything for everybody.
That's great. I think you're planning to give the states more flexibility, so you're on deck.
And that's what we need, and that's what we should have. What I don't want to see happen, if we get a favorable ruling on this, is the states being forced into basically doing the ACA backdoor on it. And that's the thing that most of the states are pushing back, is don't force it then in the system. You've put subsidies in some places and not in others. Okay, now you've got to do the ACA or else you don't get the subsidy. And that's not what it should be. And let me make one other further point. I was in the Senate when the ACA passed. I fought against it there. I fought against it as governor. This is what happens when you have a bill written not in the light of day, not going through the normal committee process, that's written in the offices of the majority leader or the speaker. So then you run somebody in the office, what do you got to have? I got to have this. Okay, what do you got to have? I got to have this. And you write it in, and then you run it out, and you make everybody vote on it. And Nancy Pelosi says, we got to pass the bill so you know what's in the bill. Well, that's because the bill didn't pass in the light of day. And then you get things like this that get into the bill that they're going, oh, we didn't think about that. Well, no, because you didn't go through the normal committee hearing process and look at it, and now you are where you are. And that's why you need to have things following normal order and a president that would follow the normal process in implementing a bill as well.
I think that's great. Now, I just want to turn, we've talked about government solutions. Governor Brownback, I know you're also a champion. It takes civil society as well. If we want a limited government, we need to strengthen civil society. And I know you've done quite a bit in your state in helping reach out to those civil society partners where government shouldn't be, or it has failed to do a good job. Can you give us a couple of examples? And I wonder if the congressman can also talk about, are there some ways that we can take some of the obstacles out of these civil society solutions? But if you could share one of the projects you're working on.
You know, I mean, the system, again, I always think you're best off if you do the system the way it's designed to work. So the federal government's to be limited, state, individual, have the general authority. It's also a system that's designed for maximum freedom and personal responsibility. That was the initial design of the system, and it works best that way when you operate the system that way. One of the things that we look at, and we've got a tough problem with prison recidivism. Once people go into the system, they tend to go back into it. And what you need is really to build and to have people come around the individual once they come out of prison. They've got to do their time for the crime that they've done. But once they come out, you need to have people come around them and help them, because if the government is there trying to help them and hug them, the government hugs with very stiff arms, if at all. And if the government goes to hug you, run, okay? That's just not a good place to be. But what we've done is build a mentoring program, private mentors for people when they come out of prison and while they're still in, to say, look, everybody has problems and we want to help bring other people around you. But they do it as individuals. And it's generally a faith community, people stepping up, and that has cut our recidivism rate from about 20% on the first year out to about 9% of people that take a private sector mentor. They're not paid by the government. We do recruit, we do try to help match people up, but they can build that personal relationship that the civil society only and the individual can do, not the government.
That's great.
Well, to take up 2 points that the governor has raised. First of all, with regard to this lack of transparency in Obamacare, it's pervasive in this administration, and not always in places that directly affect the states. I would argue that what was just done by the FCC this week in a narrow 3-2 vote was done in secrecy. It was done. They've come up with a document that we haven't gotten to see yet, but Ajit Pai showed us in a picture how thick it is. Hundreds and hundreds of pages put together by secret meetings and so on, and the public had no input into that. So we've got to change that first and foremost. But secondly, it is so important that we go back to this 10th Amendment and remember that really the whole concept of the Constitution and the protection of the Constitution was based upon the power of the people. The 10th Amendment is power is expressly reserved to the states, and if not, then it's to the people. And so individual responsibility has got to be the foundation of government at every level. And in fact, I'll stop here with a quote. One of Virginia's first 2 senators, Richard Henry Lee, didn't think the 10th Amendment was strong enough. He thought because the 10th Amendment referred to the powers delegated to the United States and not the powers expressly delegated to the United States, it left the new federal government free to claim broad implied powers were delegated to it under the necessary and proper clause. How amazing, back in 1790, this guy got it way back then. And what if we had put that one additional word in the 10th Amendment? How much better off we'd be in keeping the size of the federal government under control.
One word, one word. Lightning round. I wonder if I could just ask each of you, you all are tremendous tormentors of this administration, tenacious tormentors. Who else should our audience be looking out for as leaders across the country who are fighting this bold fight, who are champions just like you? Who should be on their radar screen? A.G. Pruitt, can you start off?
Well, I feel like we've got a Delta force of attorneys general out there working together in multiple states, and I have good friends in South Carolina and Florida and a collection of folks in Texas. Greg Abbott and I used to kid each other. He had about 13 or 15 cases against the EPA. When I first got elected, I was trying to catch up, and he never slowed down, so I never quite caught up. But we've got a great collection of individuals that are out there working across the country, making sure that there is adherence to the things that we're talking about. I do want to share one thing real quickly, Bridgett, about the Affordable Care Act issue with respect to the subsidies. There's so much discussion, and the chairman's talked about it, and so has the governor. There's been so much discussion about saving the subsidies. You need to keep in mind that if the subsidies are saved, and that's the only focus of the reform that's done in Congress or at the state level, it brings and invites into the states the employer mandate penalty and the enforcement of the individual mandate. All those things are tied together. So the decision that the governor made in Kansas not to set up an exchange meant that not only would the subsidies not flow in Kansas, but the employer mandate penalty could not be assessed. We had a company in Oklahoma called Hobby Lobby that, as you know, took a strong stand against this administration and was facing $1.3 million a day in fines. If we win this case, that amount of money would not be able to be assessed against Hobby Lobby in the state of Oklahoma or in 36 other states. That is huge as it relates to the enforcement of this law, and we can't embrace it.
Well, I'll give another shout out to the Attorneys General. They have set up an organization called the Rule of Law Foundation, which is leading the fight in these lawsuits. You mentioned Alan Wilson, the son of Congressman Joe Wilson, who I'll also give a shout out to, who's called Truth to Power, as you know. They're doing great work in that, and I have tremendous respect for them. But we have great people in the federal government who are trying to stand up for this as well. And Ajit Pai, let me mention him again. What a great job he has done. Just a 2.5-year member of the Federal Communications Commission, but he's standing up for individual freedom and for less federal government regulation in ways that I think are just tremendous. Lots of members of Congress in the House and the Senate. We always need more, particularly in the Senate, where, as Sam knows, we got to get that 60-vote threshold or change those rules. But we're working hard, and then really the fact that we now have so many governors like Sam Brownback that are going to stand up for their states and for the people of the whole country, really, by having the Constitution interpreted the way it should be.
Great. Last minutes for you.
Attorney Generals, Ajit's a former staff member of mine from Kansans, you could, in general, and then state of Utah. Watch what Utah is doing, particularly on the federal lands issue. I think this is a very interesting issue that's coming up. But there's a number of people and a number of Republican governors that I could cite. The problem is we shouldn't be here like this. But we shouldn't have to spend this much time pushing back against the federal government. And that's why I hope in 2016 you push to get somebody with a different philosophy at 1600 Pennsylvania Avenue.
Good. Thank you all. Thank you, panelists. Thanks so much. I appreciate your comments and the great words of your remarks and the terrific examples that you've pointed us all to. Thanks so much for joining us.
Bridget.